Now back to Inside Real Estate. Here's Mike the Realtor.
Hey, folks, we are back. Website, InsideRealEstateRadio.com. Website's InsideRealEstateRadio.com. Hey, if you want to talk to us, 888-787-KLIF, 888-787-KLIF. If you have any questions or just want to shoot the breeze, give us a shout. Hey, we're going to talk with good old Mr. Perry Cockerell, our resident legal expert here, about some very interesting cases and that are going on out there in the world today. And, of course, he's the author of A Private War, and of course you can check that out on Amazon, or you can go to his website, perryjcockerell.com, and to get more information as well. How's it going, Perry?
Hey, fine. Thank you, Mike. Nice to talk to you again.
Good to see you in studio again.
It's been a while.
It has been, yes.
Let me mention the book is now out in 4 parts. It's illustrated. You can buy it on Amazon. If you don't want to read a 500-page novel, you can read a 100-page novel. Let me mention, I want to give a shout out to Terri. She does a great job over at Supreme Lending, and that's a great product she just mentioned.
Yeah, it really is.
They're closing a loan for me on some property we're buying in Fort Worth, and they're doing a great job on that. So
thank you, Perry.
I highly recommend Supreme Lending.
Thank you, Perry. I appreciate that.
I really do. Well,
absolutely.
And the topic today is on some conflicts in the law, in some case law, involving trespass to realty. Usually it's when there's some boundary issues. It's adjoining property. Somebody puts something on the other neighbor or the neighbor's property, and it remains there for a period of time. The question then is, what happens? Who owns that? And disputes happen. And this is very important to make sure you get a survey, find out what's your property line, and if your fence is not on your property line, you better move it back.
Right.
Because you're eventually going to lose that property. First case came out 3 days ago, January 26th, and it was from Houston. And here there was a shed, driveway, a fence. It was built in 1941. The neighbors had a dispute, so they filed suit to declare their boundaries. And, of course, they lost. 1941, that's a long time. And so Here's what the law is. There's a 3-year statute limitation if you take title under a deed or what they call color of title, and you possess that property can become yours. And they call that adverse possession. The second one is a 5-year statute, and if you own it or if you cultivate it, pay taxes on it, and you claim it through a deed, and then there's a dispute, you could acquire title to that too. You just file suit, action to quiet title, you can own it, even though your deed might not necessarily describe that property. And that's how. Now the third one is 10 years. You don't have to have anything. You just take it, acquire it. You cultivate it, you use it, and you enjoy it. You don't even pay taxes on it. You can go to court. You can get title to that property. And those are called the adverse possession statutes. Makes sense? Supreme Court has held you can do that. Now, here is what's happening. 2 new real cases. I'm not going to mention them by name because they're both still in litigation. I'm only going to mention them because to tell you as property owners, it is never a good idea to let your boundary line be questioned or be in question. Mm-hmm. First case was a lease set out in 1994. The tenant had it surveyed in 2001 and did nothing with that survey. In 2006, the tenant moved the fence line over to incorporate some additional land. The owner did not know about that. And then the next year, the owner signed a new lease on the property, which made no reference to that survey. It made reference to the original description in the lease, which was a box, and they didn't do a survey then. And so it's not until 2013 when the owner begins to want to sell the exterior part of the land that he realizes there's something not right here. So he orders a survey and figures out they moved the fence line over. And not only did they move the fence line over, they moved it over before he signed the lease a year prior to that in 2007. So they basically gave an amendment that made no change. And now the question is, why didn't he figure that out? Well, it could be a number of reasons, but now here's what happened. The trial court said that this suit is barred under the 2-year statute of limitation. 2 year. There's another statute, 1603 that prevents trespass, other types of causes of action like car wrecks, trespass, personal injury, things of that nature. 2 years statute of limitation. And the court says, well, you can't bring that trespass suit because it's barred by this 2-year statute. Okay, now what happened to the 3, the 5, and the 10?
Mm-hmm.
Who gets the property? And the property owner wants to have the boundary line declared under a separate statute that allows you to do that. That statute has no specific statute limitation. If there's no specific statute limitations, it's usually 4 years. There's no answer to this yet. I mean, there is actually. The court said that this suit could not be brought because it was not brought in 2008, 2 years after the initial injury. So the court says that the statute of limitations runs when the trespass occurs, even if you don't know about it.
Yeah, that would be frustrating as a landlord because, many landlords, are not in the same city, same state as the property that they own and may not visit it very often at all.
That's exactly how these are happening. They're commercial settings.
Yeah.
They don't realize that you're coming to sell the property and you getting a survey. That's when this dispute happened. That's what happened in this one. So nevertheless, though, the possession of that area had only been going on for 7 years. So the trespasser who alleged adverse possession under the 10-year didn't prove that he had it for 10 years, but how could he win the suit? He won the suit because this other statute is kicking in and playing. So what this implicitly is saying is that there's a 2-year trespass statute of limitation that is overriding the adverse possession statutes. That's a conflict. Okay.
Yeah, absolutely.
Now, another case that came out December the 1st figured this out, and this is case 2. Same thing. They built a wall on a piece of property. The owner had access over the adjoining lots. That wall effectively denied access. The wall was built in 2009. Suit was filed in 2013. What does the trial court say? Barred by 2-year statute of limitation. Court of Appeals figures this out and says, oh, wait a minute. Hold on here. This is not right. The 2-year statute of limitation is intended to limit the amount of money that you recover. Damages. Does that make sense? The legislature is intending to cut off the damages for the possession of that property. Mm-hmm. It wasn't intending to say you can't remove them.
Right.
So they reverse that case and send it back and say, no, the action to remove you is governed under the 10-year statute of limitation. That makes sense, doesn't it?
That'd be correct.
That makes sense, yes.
Doesn't that make sense to anyone here?
Yeah, that'd be correct, yeah. The way I would understand it, yeah.
Of course.
Yeah, I'm not a lawyer, but that makes sense to me, too.
Doesn't it?
Yeah, you can't just have my property.
Because
I didn't notice it.
Because I didn't sue you,
Right.
even though you didn't possess it for the number. That is what's happening. Now, there are calls out to legislators who have been sent these 2 cases and saying, do something. The last day to file a bill is like March 10. Clarify this statute. Now, there is a case pending in the Texas Supreme Court. They initially denied hearing it, but there's a motion for rehearing. I don't want to get into the specifics, but here's what the concept is coming down to. There's the 14th Amendment due process. You can't deprive somebody of their property without due process. So there's no hearing. There's a statute in Texas that allows you to have your boundary lines declared, but you apparently can't do that under this too. And so effectively what the attacks are not just that case and other cases, including this one in Corpus Christi. They're attacking it under the 14th Amendment due process clause, or the due process clause in the Texas Constitution. The other attack that can be made, if there's other litigants out there like that might want to look into it, is there's the equal protection clause under the 14th Amendment of the Constitution that says if you're similarly situated, you need to be treated similarly. Usually,
right.
Now here, the property owner and the trespasser are similarly situated on the same property. They have the same interest. Mm-hmm. But the trespasser can not prevent the owner from kicking him off by alleging the 2-year statute of limitation. When the statute gives him 3, 5, and 10 to acquire the property.
Right.
So the owner has a 2-year. The naked trespasser has 3, 5, 10. He's being treated differently.
That's crazy.
Doesn't that make sense?
Yeah, to me, I don't think that, to me, the 2-year, statute of limitations should not apply when it comes to property rights. That, to me, it doesn't, the 2-year statute of limitations, for if you get into a car accident and you decide to sue somebody for, some, damages, and
right, that makes sense.
That makes sense. 2 years, makes sense. But when it comes to property rights, it should go to what has already been established, 3, 5, 10.
It should. Now, this is not a new concept. If you go back many years ago, even some of these papers written 10 years ago, there's articles that say the 2-year statute of limitation is the trespasser's best friend. And this has just been under the radar all these years. Nobody's been able. It's not an issue that makes people jump out. If you call someone, they don't necessarily want to go to Austin over this. I mean, it's not that kind of issue that brings out the crowds. They're not going to be protesting.
Yeah, they're not protesting that.
They're not going to be.
It's not
they
be
might
much
be after
signs.
this radio show, Perry.
They won't
We may have given another reason for them to protest.
That's right.
This is a simple cure, and there's no reason to go into the constitutional, the federal constitutional issues, really, because it's just an interpretation issue. Yeah. It's kind of under the radar.
But it seemed, to me, if this is coming to court, it seems to me like this is just obvious. Why is this? Why are they allowing this 2-year to kick in, and why aren't, to me it seems obvious from a judgment point of view how this should be ruled. I mean, why do you?
There's plenty of other. The courts just didn't come up with it. There's plenty of precedent for what they're doing, and. But when it comes up to when it comes up to the issue of adverse possession and this statute, that's where it's starting to the big picture starts kicking in. You really see usually where the 2-year kicks in. Here's why it's an issue: is let's suppose you pour chemical on somebody's land, and this happens. It's oil and gas usually. The question then becomes, if it's a permanent injury to the land, then you get the fair market value, the loss of that. And this permanent, now if it's what they call a continuing trespass, something that's ongoing, then you can continue to bring that suit because it's not a permanent. And this permanent temporary distinction is what's leading to the confusion between in the damages. So the 2-year was designed to limit somebody for suing them when the damage to the real estate itself was permanent. I don't believe that 2-year was intended to prevent you from removing the trespasser from the land. It's
exactly
if you damage somebody's land, like chemical exposure, or do something that damages it, causes the fair market value. That 2-year was designed to limit the damage, kind of like a car wreck. If you don't bring suit in 2 years, that's where I think the legislature had in mind. You never know. We'll just see how it plays out.
Right. This is very, very, very interesting. So, folks, hey, for the property owners out there, whether you own, a small subdivision lot, small home in a typical subdivision, to a state lot or to a ranch with heavy-duty acreage, or you run a hunting lease, whatever the case may be, the point is you need to visit your property. You need to make sure there's no encroachments on your property by other landowners nearby you. You need to make sure your property lines are on the fence lines, and that, sometimes over time those things can be moved by neighboring landowners. You want to make sure that your fence lines are on the property lines, and just make sure you're looking out after your property, and especially if you're an investor, and you have rental properties, et cetera, you need to look in on those. Don't just take a property manager's word for it, because at the end of the day, you own it. You're liable. Make sure you go in and inspect your properties from time to time. That's an important part of this. And so, hey, great stuff, Perry. Hey, Perry's website, perryjcockerell.com, perryjcockerell.com. Folks, we're going to take a short break, and then we'll be right back.